Right, welcome everyone. Let's give it a moment for everybody to log in. Sometimes it takes a minute for Zoom to allow everybody in. And we'll just get started momentarily. Thanks for joining us. All right, it looks like we are at time, so let's go ahead and get started. I want to thank you for joining us for the Around the Valuation World this month. My name is Chun and I'm with NACBA and the Consultants Training Institute. Before we get started, I just want to go over a few housekeeping items. First, to obtain CP credit, you must answer all the poll questions that pop up on your screen during today's webinar. If you have any, CP certificates will be available within 7 to 10 business days after today's webinar. If you have any questions during today's webinar, please feel free to use the Q&A option through Zoom, as those will be directed to the presenter. If you have any technical questions or questions about NACBA, please feel free to reach out to me through chat, and I can assist you with that. And with that, I'm going to turn the time over to Alina, who will get us started with the first presentation.
Thank you, Shanda, and hello, everyone. I hope you have been having a great, starting of the week. And for all of you that were on the conference, I hope you had a wonderful time. So today we are starting our ABW show for the month of July, and we have wonderful sessions. We have Michael Gregory. He's always with us with different industry headlines and information about things that are really important for us in our when we are doing business valuations and litigation support. And he's going to be interviewing David Adams. So they are going to be talking about a specific case that was discussed last month. We also have Michael Pakter. He's going to be talking about bankruptcy, insolvency, and restructuring. And we have one of our sessions that people loved with the judges. We are going to have Janae Castell, one of our correspondents, interviewing and talking to them today about what to do when you find errors in your work at a trial. We are also going to have Karen Caseno and Jeff Urbach that they are going to be discussing federal and state case law summaries. And Will Casserly is going to be talking to us about volunteering with Start Small, Think Big. So right now I'm going to let Michael Gregory, that he's going to be doing his session. And all of you probably know Mike. He knows a lot about the IRS. He's a mediator. He's also do business valuations. And he's been assisting us for a long time. He's one of our correspondents, and he has the knowledge, experience, and relationships to help you and clients with IRS and other disputes. So Mike, you can take him from here. Let's see if he's around.
There we go.
Oh, you're there. So let's see if you're presenting. That's your presentation. That's great.
Okay, you see one slide. We're good to go, Elena?
Yes.
Very good. Thank you for that introduction, Elena. And thank you, everybody, for being here today. It's my pleasure to introduce a number of topics to you, and then we're going to interview David Adams, and I think you're very much going to enjoy that interview. For today's topics, we're going to talk about the BV agenda is released for the upcoming ASA conference in New Orleans, October 1 through 3. The Big Four are eyeing return to office mandate, what that might mean. Why are valuers changing their Excel models at this time? New edition of Cannabis Valuation Book is now in BV Research Pro. Solid advice on BV career development. And Hitchner's comments on the new Pepperdine report and links to the Pepperdine report as well. So in terms of our objectives today, note that the ASA BV agenda for New Orleans conference is now available. Identify return to office implications. Evaluate changing Excel models. Identify the new Cannabis Valuation Handbook. Apply the solid advice of BV career development. And note Hitchner's comments on the new Pepperdine report. So in terms of BV agenda released for the ASA conference, we just had a wonderful conference with NACFA. We've got another one coming up here in December. In between those two is the ASA conference, New Orleans. Their major topics they've identified and are promoting are an inflation update on the cost of capital, the impact of environmental, social, and governance, which is very much on point for financial reporting. Not quite there yet for other issues. Buy-sell agreements and some issues with respect to those. Safe investments, new research on long-term growth, intangibles, and goodwill. And I'll be talking about the impact of $80 billion and 87,000 agents. It's now been reduced by the Fiscal Responsibilities Act of 2023 by about 20 billion in theory, because they took $20 billion away from what was out in years 9 and 10. And so they brought that into the current years now. So it ends up that it's no change really with that, but they are going to take away 1.4 billion in 2024. But more details on that at a later time. In terms of Big Four, I return to office mandate. The Big Four are considering a mandate to return to the office 2 to 3 days per week. They're looking at this from the perspective of what do you really need to do your job? And they're focusing on customer satisfaction. So given that customers can be treated better if they have some interaction with employees that interact with each other in the office, and that enhances employee satisfaction to an extent, they're looking at that very seriously. Managers need to set the example. So if they're going to make this mandate, then they're saying managers have to live it. In offices where the activities give no reason to come in, there won't be a reason to come in. But they point out also an analysis relative to equal employment or equity employment. Pitfalls to women and people of color are not being in the office. They've noticed over the past 2 years when individuals are not getting mentoring, and oftentimes with white males, we know we need 3 mentors. We need the mentor who's teaching us technically. We need a mentor who's like a partner who can give us the vision of the firm. And we need a mentor who can tell us, how do you really get things done here at our firm? If you don't have those, you're more likely to quit if you're not coming into the office. So looking at this as it's also an equity employment issue for those who come with people of color and women diversity. So why are valuers changing their Excel models? Excel models are being retooled to address several things. First of all, and most importantly, the uneven impact of inflation on expenses. Some are not really impacted, others really are. So the question is, which ones are and how much might you have to change your overall Excel model to make more adjustments to your forecasts? There now may be up to 10 more adjustments that might be possible. You don't want to simply run your ratios without having given this some thought. You probably need to dig deeper, making more reasonable adjustments, and then document whatever it is you're doing and why. The new edition of Cannabis Valuation book is now out. I'm in Minnesota, and July 1 of this year, cannabis became legal, but it's actually a 2-year process. So by July of 2025, everything will be implemented. It's a phase-in of several things right now. But for folks like, for example, in Minnesota, I have recommended this book to over a half dozen people just this month. I'm saying, so you don't know what the federal laws are, you don't get those expenses and things, but there are things you get as a state law now. So how does that enter in? And I've said, this is the book you want to have because it addresses the cannabis industry on both accounting and appraisal issues. It addresses the unique financial aspects and intricacies related to operating a cannabis business. I'm no expert in it, so I look to a book like that for insights and to advise others. A sample risk assessment framework and an appraisal report should be tailored to the unique demands of your industry, and this book will help with that. In terms of solid advice on BV career development, at the conference that took place June 8th by ASA on this topic, Professional Development and Growth Conference, the overall theme is, in today's world, we're going to need to become specialized. Specialization is going to be the key to the profession and your survival. So you can look at that by industry, by type, by purpose. The conference was sponsored by Empire Consultants, and they focus on saying, there's a natural progression here for folks who are specialists. If we look at this, we can come back in and say, same thing has happened in law, in medicine, in technology professions, in getting certificates in specific areas. So the key is not just the technical, it's also the soft skills. I made a presentation of 560 CPAs last week. And I got a great score of 4.74 on a 5.0 scale. And over 20 people gave me comments. But the most significant comment, I think, was from a person who said, I always focused on the technical work when I was in the profession. I'm now retired. I'm now taking soft skills and courses. What I should have done is taken those throughout my career. And that's what this is saying. More soft skills are needed by the young business valuers. And managers need to be there to develop their staffs. Hitchner's comments on the new Pepperdine report. Very quickly, it's there, good information, it's free. It addresses the different items that are listed here. 27% of respondents indicate that they use this as one of the sources in estimating the private company cost of capital. He gives out a number of positive pointers with this. And thanks to a sponsor, it is free. So you can download this for free. So as you look at this, here's the ASA BV Discipline Track session in New Orleans. Here's the new cannabis book. You can buy it for $129. Here are Hitchner's comments on the new Pepperdine report, which I would encourage you to read if you're using the Pepperdine report, or read if you want to know more as to what the benefits might be of using it. And then there's the Pepperdine report. Each month, these are the different sources that I use to bring you information, and hopefully you enjoyed today's session. With that, that's my contact information. Any questions, comments, concerns, if I can help you, come back to me at any time. Now we're going to move into the, oops, there's a question. So we can answer that. And I'm going to take you into the next session. And I'm going to bring on board Mr. David Adams, CPA, ABV, ASA, and MBA. I'll tell you, David Adams is the expert's expert. He's an expert in litigation. Those are his credentials. He's the president of Adams Capital, LLC. He focuses on valuations of businesses, business interests, mergers and acquisitions. And he has over a dozen professional memberships. Those are just a few of the letters behind his name. He's located in Atlanta, Georgia, and he was one of the valuers on the Cecil case. And last month, you heard Michael Mulder present information relative to the Cecil case. And I thought, oh, wouldn't that be cool to interview David Adams? Because the court actually went back to him after the case and said, help us put the spreadsheets together to address what we indicated in our case. So with that, I'm going to bring on board David Adams, and we'll start to talk about the case, and then we'll have a little bit of Q&A here towards the end. David, are you there? And Chinda, is David Adams on board?
I'm here. Can you hear me, Mike?
Yes, I can. Welcome, David. Good to see you. How you doing, my friend?
I'm doing great. It's a beautiful day.
Well, I'll run through the slides for you if you just want to make some comments with respect to the slides, and I'll just keep moving through as you go through the slides. How's that?
Sure. Well, I think just it's helpful to have a little background on this beautiful national treasure. You're looking now at a picture of the front of this house, 175,000 square foot home. And I think that's it's on about 8,000 acres or left. There might have been 125 acres before the family started paying tax, but Pisgah National Forest is one of the benefits of a prior Vanderbilt family tax payment. So we're all enjoying the Vanderbilt, we'll call it charity, but they certainly had an eye for beautiful property. I actually grew up, my first visit to this house was when I was 8 years old. I attended a summer camp around the corner, and my mom was fascinated with the house and would take me and my brother and sister, and they weren't as into preservation at the time. The house was open to the public, but we could run, we could go in the library and look at the books, like pull them off the shelf and flip the pages. You can't do that anymore. They're very particular about protecting the family legacy, and it's open to the public every day of the year. And if you haven't been there, I'd encourage you to go. But, my family has enjoyed many, many visits to the Biltmore House and Gardens, and it was quite the privilege to work with the family on this tax matter. So let's get into some of the specifics of what we were tasked with valuing. There was a probably the largest debate between the IRS and the taxpayer early on was, are we valuing a controlling interest with the ability to liquidate or a minority interest? And it really took the tax court to help clarify that that was indeed that it was a minority interest. And I see a question. TBC is an abbreviation for the Biltmore Company, which is the owner, technical owner of the house. But we valued the minority interest and or several permutations of a minority interest, but for our discussion today, they're all about the same, except the tax court did decide 3 different discounts applied depending on the characteristics of the minority interest at hand. Not a significant distinction in terms of economics for the taxpayer. The IRS and the IRS's expert continue to sort of hang on to this asset approach, even though Mr. Morrison, the IRS's expert, only weighted his asset-based approach 10%. They still value the art. And it just didn't really flow well compared to the family had, let me back up a minute. This family was awesome to work with. They had wonderful facts. They were great people. They view themselves as stewards of this wonderful asset, and they their mission is to share it with the world, to share it with us. So again, I encourage you to go visit. But they actually speak across the country about family legacy and keeping assets like this Biltmore House and Garden in the family. So we had wonderful facts on, if you think about on an income approach, terminal value. When are we going to liquidate? I just threw out 30 years, and court agreed with that as a reasonable time frame based on the testimony of the taxpayer. So it wasn't really me winning that argument. It was the taxpayer made a compelling case in tax court. But I was persuaded when I interviewed them. Nonetheless, we also had an asset approach with a lot of land being valued, the art in the house. There are 92,000 artifacts in this house. So I guess the IRS just cherry picked 4 most valuable pieces of art and had those appraised.
Now here's a summary from inside the case with the different classes of stock. Your values and Hawkins and Morrison were 2 appraisers for the IRS, and just overall what the numbers look like here, David. So yours, you have it with on the Class A stock tax affecting. Then Hawkins has it with tax affecting, and Morris has it with tax affecting. And then for the Class B stock, you did it with both tax affecting and without tax affecting. That's a smaller block of common stock. Hawkins did it with tax affecting and Morrison with tax affecting. And then in a Class B stock, you had it with tax affecting and without. And then Hawkins and Morrison with the IRS both did it with tax affecting. So the discounts ended up being applied to all 3 of these in these different categories: Class A common, Class B common, Class B common in the larger block. That's just an overall summary, just as a reminder what the numbers were.
And I think another, my point is both our values and Hawkins' values were well below the value that the taxpayer had filed on their initial return. And maybe one of the reasons that we were successful in this case, aside from having great facts, was that the IRS even picked this for an audit. Maybe not their best decision, but I think they expected it to be settled. And by the time we got to tax court, it seemed that they weren't as prepared as I think they probably could have been. So we maybe got lucky there. I've seen the IRS be far more prepared on other matters. So but nonetheless, we were prevailed with basically pretty close to what myself and Mr. Hawkins came up with. And the tax court, Pamela Johnson, was, I felt, an excellent judge, very much on top of the facts. And the IRS just didn't put up a great argument. And I was in the courtroom. I got to see, and it just wasn't. It wasn't well thought out and well presented.
Well, here's a quote from within the case here too. Would you care to make any comments about this quote within the case here, David?
Let's see. This is about the tax affecting, and we didn't want. So I've spent a lot of time with the attorneys on this item before we ever got to court. Did not want the experts thrown out because of tax affecting. Tax affecting really was a small component of the overall valuation. And tax affecting or not, if we won on the income approach versus asset approach, we were a big winner. And so the tax affecting, we did 38% and 21%. The court ultimately decided 17.6%. So we just, in the end, after the decision, which was a little unclear numerically, I read it a few times, looked at our model, looked at what our tax court had said they wanted us to do, and I made, basically, I made an adjustment on tax rate, and I made adjustments on black marketability for each of the 3 different blocks of stock. And those were the only adjustments that I made, and the IRS accepted that.
So when we take a look at this, what was it? What do you have in terms of comments of what are you valuing overall, valuation methods, and any comments on the DLOC, DLOM, or tax affecting? Any additional comments?
Well, we valued the minority interest in the shares, which was a portion of the business, but not all of the business. And we held that the shareholder of the minority shares had no ability to get at the assets. The IRS had started the audit with an all-in on the asset approach, and that changed over time, but there was still just a little bit of asset approach left in their position. And it was counter to the families. This family, to be in the family, you have to have a prenuptial agreement. You have to work at the company, but only after you earn a college degree, and you have to work somewhere else first before you can work at the company. I mean, they are really focused on keeping the family diligent about holding this asset out for really public consumption. And then on the valuation methods, one of the things that I suggested is the real comparables for this are museums and nonprofits and national parks. They're not for-profit companies. The fact that they actually make a profit is pretty remarkable. And in fact, under profit on their website, this family talks about a commitment to supporting the public interests and seeing the estate, not about maximizing wealth. So kind of a refreshing perspective on money. Let's see, on comparable selections, they were difficult to pick, as they almost always are. And I think the court correctly picked on a few of our comparables. One was right in the middle of the financial crisis. Perhaps it was a comparable that was influenced by the financial crisis, and we were past the financial crisis on this valuation date. So I think the court suggested we probably could have left that one out. And but then in the end, we weighted the income approach 50%, and we rated similar transactions 50 or 25%, and the public comparables 25%. And I guess because we weighted lightly some of these problematic comparables, the court gave us a little bit of a hall pass, but they said because we weighted them not so much, they were not as focused on them. But, I've seen a number of cases where selection of comparables and having the comparable truly be comparable or not comparable at all. And the court kind of highlighted that I picked a few ski areas. I like to ski. I'm very familiar with the ski areas. I felt they were comparable in terms of income generation, that they get people out into the facilities. And the Biltmore House and Gardens, there are more people who go to the gardens every day than go in the house. The gardens are the big attraction, which even though it's a very large house, the gardens are even larger.
Hey, David, we got a question that came in, and I should have put this in here. Do you remember what the date of valuation is of this, or what year we're talking about this valuation?
I saw that question, and it's been so long.
And this case was a long case in getting out of the court. Usually the tax court makes a decision in about a year and a half after they've had the trial. In this case, this went on 6 years. This is an unbelievable long decision before this decision came out from the U.S. tax court. It's the longest one that I can recall. It may not be the longest one, but it's the longest one that I can recall related to a valuation case.
I can get back to you on that. Well, actually, I may have it here, but it's at least 10, 12 years ago.
Yes.
Yeah. 2010.
Okay, 2010, and the decision came out in 2023, 13 years from the date of valuation until the decision, and 6 or 7 years from the time it finished in tax court until the decision came out. Shows you just what can happen. And I think this case had tax affecting by both parties. It had the SEAM method used by both parties. And the court was trying to figure out, I think, what to do with it. But finally, we got the decision. But the court also shared some things with us of what they didn't like, too. Do you care to comment about any of these?
Sure. In our standard report, we have some very old discount for lack of marketability data. And we we explain that it's old. And we make a point that if there was new, better data, that somebody would have published it. But they still didn't like our old discount for lack of marketability data. Okay, that I mentioned already the transactions during the 2008 financial crisis. They didn't like my one-size-fits-all discount for lack of marketability, which was 30%. Instead, they gave us 3 different ones. The smallest block of stock the court determined was the most marketable, and the largest block of stock was the least marketable. To be fair, I thought that was so obvious that a larger block would be more marketable and a smaller, less marketable. But when I look back at my report, I didn't clearly make that argument. I didn't even realize that was an argument that I needed to be making. So we'll fix that in the future.
And any comments about Georgia Tech?
So there are 4 experts in the tax court case. The undergraduate school for all the other experts was mentioned. For some reason, my alma mater, Georgia Tech, was left out of the tax court's opinion, and I am a little perturbed by that. But otherwise, I thought it was a very fine opinion.
Okay. And would you care to comment about some of the conclusions on the case here with the DLOM and the issue with respect to tax affecting, and then talk about what happened after the case closed out? This is a very unusual situation. I'll make some comments there too.
Well, it was nice. They accepted our discount for lack of control at 20%, but adopted Mr. Morrison's discount rates 19, 22, and 27% for discount for lack of marketability. Compared that to my flat 30%. I didn't really differentiate these 3 different blocks. There was really, other than they were all minority, but the court took a different perspective. And then on tax affecting, they just all the experts tax affected. This was not a case about for or against tax affecting. It was just a matter of rate, and our rate was 21 or 22%, and the court picked 17.6. We also did a full tax effect at like 38%, I believe, but we gave the court a choice on tax affecting. We didn't want that to be a reason to reject our opinion.
Well, one of the things that was interesting to me on this case is it came out February 28th. And I read the case 3 times when it came out. And in the body, it said, we tax affected at 17.6%. But in the conclusion of the case, it said we did not tax affect. So those 2 things were inconsistent. So March 1st, I contacted the U.S. Tax Court and I said, hey, this court case just came out and I'm confused. Did you tax affect or not tax affect? And the person who took the message was just somebody taking the message. But the next day I got a call from the clerk of one of the judges, and I explained what my question was, and they understood, oh yeah, this is a problem. You can't inside the text say we taxed affect at 17.6% and the conclusion say it's 0. And that's all I knew at that time. And what I didn't know is the tax court came back to you and said, help us out with our computation here. And you spent about another month and a half in working with them. And they took your spreadsheet and said, let's work with you and your spreadsheet. And you put these numbers in for us, including the 17.6% tax effect. And so in essence, you know the final numbers because you put those together. Do you care to comment on that at all?
Well, that's exactly what happened. The case said it both ways, but it seemed to lean into the 17.6 was, for this case, the right number. But throughout this case, and my experience with the IRS, I've always tried to share our models with the IRS. And that has facilitated the dialogue with the IRS, because now we're just talking about changing one or two variables, not the entire methodology. So we had a long history of sharing our models with the IRS during this case. And when it came time to finally resolve it, we just followed that same path. We really had a good relationship with the IRS during the entire case. In spite of the debate, we were very cordial and working towards trying to get to a resolution outside of court. We didn't make that happen, but we were trying.
Well, when you stand back now, there's really three big elements that as you and I talked. The first one has to say with what is it we're valuing? When folks are going to look at this, and some are going to say, okay, the tax affecting is a significant issue because they're following tax affecting. But in reality, what was the biggest issue here relative to the big picture of this case?
Well, I mean, what we really resolved is that we can value income. When we could all look at this grand house and gardens and believe that the assets are probably worth a good bit more than our concluded value. But a minority shareholder without the ability to liquidate or guide distributions has very little say. And by the way, on distributions, the earnings, I mean, they generate this. This is they have 3,000 employees. This is a big operation, but they have employees who are restoring and maintaining old silk. And when they do any kind of repair, it's done historically accurate as possible. So they're traveling the world, finding the original loom that the silk was made on and reweaving silk on the original loom in France. They're water fountains all through the property. And it would be a whole lot less expensive today to replumb those with plastic PVC piping, but they do it. They recreate the old iron valves and do it all in a blacksmith's shop kind of repairs. They replace the roof and hand-stamped copper shingles. So,
and all this time, and David, all this ties into, in this case of all cases, you had like the ideal facts, the prenuptial agreements, the way they handle issues with respect to shares of stock in the family, all the restriction covenants that they have. This is a very unique case, which really sets you up for success overall in the case, wouldn't you say?
It did, and our legal team was outstanding. We have David Autry and John Hackney were our lawyers, and we spent, so I'm in Atlanta. David Autry picked me up in Atlanta, and we drove 5 hours or so to Asheville. And we role played the case all the way there, all the way back. And this was before there was even going to be a case. Like, we were just working on our valuation report and doing field work. But we were already planning the case and already working on the testimony and the points. So by the time we got to court, it was a polished show. I mean, we really knew each other well, and that was another key to the success in the case.
Well, listen, Dave, I want to thank you very much for being on board with us here with Around the Valuation World. Everybody wants to get in touch with David, there's his contact information. You can tell by listening to him. A very calm, confident, competent appraiser, excellent in litigation, knows his material, knew how to address this court case, and the court reached out to him to work on the spreadsheets for the month and a half or so after the case. So I want to thank you for sharing your insights with us here today, Dave. It's been a real pleasure. And with that, I'm going to bring it back to Elena. Thank you, Elena. Thank you, David.
Thanks, Mike.
Thank you to both of you. Thank you, Mike, because you always finish, on time. So for everyone else, now we have one of our polling questions. So make sure you respond to that. And we are gonna go with Mr. Pakter. He is gonna let you know in a couple of seconds. Mr. Pakter, he is a CPA, a CFF, CGMA, and a lot of other certifications. People are bullying me because of my certifications, but he has lots of them, and he's very knowledgeable in topics that are related to litigation and other matters such as lost profits, lost earnings. He works with forensic accounting, financial analysis, investigations, and business valuations. He provides consulting and expert services regarding economic damages, forensic accounting, business interruption. This is the season common for business interruption with all the hurricanes. And he also has more than 40 years of experience in accounting, forensic accounting, and all those related matters. So I'm gonna let Mr. Pakter, so he has time to talk about all the topics related to bankruptcy and turnaround and insolvency. So welcome, Mr. Pakter.
Oh, thank you so much for the introduction. So after that session, this is definitely something completely different. In getting ready for the session, I asked ChatGPT for a suggested bankruptcy joke, and I got this. Why did the bankrupt bakery go broke? Because they couldn't make enough dough. All right, moving along. What I'd like to discuss is some current trends in bankruptcy, and from Vice Media to Bed Bath & Beyond, bankruptcies are picking up again. In May of this year, corporate America had the worst 48-hour stretch of bankruptcies filed since at least 2008. I guess that's never a good comparison unless you're making a living out of bankruptcy. So more than 230 companies filed for bankruptcy in 2023, and many of those companies have similar traits. The big themes are that they have degraded their operational quality, and they have debt that is unsustainable, and that's currently the formula in this market. Retail companies are some of the hardest hit in the current environment because they're particularly susceptible to changes in consumer buying charges. Party City, Tuesday Morning, David's Bridal are just some of the retailers that have filed for bankruptcy this year. Companies with weaker balance sheets are continuing to feel the pain all through the year. The corporate default rate for companies with lower credit quality are expected to peak in the next 12 to 18 months. And that really depends on how much economic growth is expected to fall, whether there will be a recession, whether there will be a soft landing. So as I said, there's been more than 230 corporate bankruptcies in 2023. The year's not over. This is more than double the number of filings in the same period in 2022. And I would say the key factor is obviously the interest rate hikes, the high interest rate environment, and also a very severe clawback on bank lending. Even debtors who are able to pay the higher rates just sometimes cannot get their lenders to go along with them. So the period to date in 2023 is the highest total of any comparable period since 2011. 57 bankruptcy petitions in February, another 54 in January. In May of 2023, you had several companies filed: Diebold, Nixdorf, Envision Healthcare, Vice Media, Jenny Craig, Bed Bath & Beyond, Meridian Restaurants, Tuesday Morning, JDI Data, and many more. Bankruptcies with more than $1 billion in liabilities include Bed Bath & Beyond, Diamond Sports Group, Party City, and these are generally companies that are filing Chapter 11 bankruptcies because while they cannot pay their debts, they're hoping to continue to operate under some kind of reorganization plan. So the question is, how can you as business valuation professionals, and many of you with particular bankruptcy valuation experience, how can you get more of this work? And what are the areas in which you may have specific specialization that you can benefit from this increased bankruptcy level? With bankruptcy, generally, there are winners and losers. Bankruptcy is a system to reset a company and intended to cause, the creditors to settle up in an equitable fashion. So there's usually a fair amount of litigation services work. There's a fair amount of business valuation work. So let me spend a minute talking about how you can get more work in this area, and then I will go back to some trends. A key way to get more work as a bankruptcy professional, as a business valuation professional in the bankruptcy world, is to develop your expertise. You should try get specialized knowledge and experience in bankruptcy, insolvency, and restructuring. The NACVA has clearly several business valuation programs, but the NACVA also has several bankruptcy, insolvency, and restructuring programs, including one of the paths to the MAFF that will allow you to get that additional certification. You should network with professionals, sometimes building a strong network of contacts with other NACVA professionals or insolvency practitioners or bankruptcy attorneys will help you to develop the network to get that additional work. You should join professional organizations and bar associations that will help you meet bankruptcy attorneys. You could also find, if you go to the federal court website or the U.S. trustees website, you will find a list of panel trustees in every jurisdiction. And those are the professionals who have been appointed by the U.S. trustee to administer Chapter 7 liquidating trusts. And the names of all the panel trustees are listed. The names of the new subchapter 5 panel trustees are also listed, and you can contact them. Probably know several of them in your jurisdiction as well. You can publish articles, speak at conferences. You could do continuing legal education presentations at law firms on business valuations. You can leverage your online platforms, develop case studies, testimonials, expand your LinkedIn site and other kinds of social media. If you're on the creditor side, you could expand your networking with lenders and banks. One of the particular issues involved in valuation in bankruptcy is that there's going to be an expert both for the debtor, usually, and for the creditors. There could also be a separate business valuation expert for shareholders, secured and unsecured, or the creditors committee could have a separate expert. So you not only should you look to reaching out to debtor side, but you can also reach out to creditor side. Some CPAs and some CPA firms prefer debtor side work. Some prefer creditor side work. There are advantages and disadvantages to each, but you should play to your strengths and work with your network. The other advantage of providing business valuations in bankruptcy, insolvency, and reorganization work is that if you have worked on the restructuring, it's also possible that you could work on the litigation if the restructuring doesn't work. It's also an opportunity to provide value added and other services. Let's consider now the various areas in which your services could take place. So one of the areas that is causing this bankruptcy is interest rate increases. And when there might be restructuring of interest rates with secured lenders, there would be opportunities for you to do forecasts and projections in which you would have to consider various alternative interest rate scenarios or inflation. Another factor to take into account is your forecast of credit market conditions. Let me now turn my attention to the various sectors. Again, if you have particular industry expertise in any one particular area, you should consider following that up. Now, at the current time, some sectors are having more or less bankruptcies than others. So let's take a look at the various sectors one by one. Let's first look at healthcare, and the pace of healthcare Chapter 11s has picked up considerably, particularly in the latter half of 2022. And healthcare is an area where experts foresee a significant increase in Chapter 11 and bankruptcy filings. Financial services is probably the currently the big gorilla of bankruptcy filings. The financial services sector has the financial services and the healthcare sector together have accounted for 7 of the 10 largest Chapter 11 bankruptcy filings in 2022, accounting for more than $80 billion in liabilities that need to be resolved in bankruptcy. The year before that, the statistic is 30 billion. So the amount of liabilities that are being reorganized, whether in or out of the bankruptcy court, has gone from about 32 billion in 2021 to more than 80 billion in 2022. Another area that is experiencing distress requiring bankruptcy, insolvency, and restructuring is the automotive industry. And there it is more a technological disruption because of the increasing move towards electrified vehicles. And besides interest rates and electric vehicle headwinds, traditional auto suppliers are facing near-term operational challenges regarding supply side, particularly in an ongoing semiconductor chip shortage, and the problems of the motor vehicle manufacturers are rippling down to the next tier of suppliers. And the next tier of automotive companies supplying parts and services to the big manufacturers are seeing a very significant contraction in their gross margin. I have done some work for suppliers to the automotive, to the big three in Detroit, and every single year their margins are squeezed. One of the particular matters that I'm working on is that the internal audit division of a large, one of the big three motor manufacturing is effectively a profit center. It's intended to audit the suppliers, not just to ensure compliance, but basically to twist arms to get all sorts of credits and rebates during the audit process. The auditors are not really auditors, I find, so much as trying to get credits and recoveries under the threat of audit or the threat of not renewing a contract. So tier one suppliers in particular are facing the squeeze from the original equipment manufacturers, OEMs, and they have, besides technology issues and high interest rate environment, they're also facing declining margins. Consumer markets are facing their own difficulties. Also, they're facing margin pressures from rising costs driven by inflation and unique inventory supply challenges. There's also some companies are facing declining consumer sentiment, and some areas of the consumer markets are just facing decreased demand. Crypto companies have had their own particular crypto winter, and they've taken a hit to asset prices, and several trading platforms have been hit. Trust has been undermined, which has led to filing of bankruptcy in many crypto traders and crypto markets. Health services, as I mentioned, are suffering from the end of the temporary safety net measures of government support that were provided during the pandemic. Healthcare organizations are facing situations where they have declining ability to hire and retain professionals. They're having difficulty with reimbursement rates from the insurance companies. They're facing no government support on because the pandemic measures have ended. They are also facing cost pressures, and they're facing an increasingly difficult regulatory environment, and that's particularly the sources of stress and distress in the health industry. Industrials are facing complex global supply chain and inflexible pricing arrangements. They're not able to pass on price increases to their customers. They don't have the pricing power to pass on inflation rates to others, and that's the particular cause of their distress. Pharmaceuticals and life sciences companies are facing a challenging year. Their particular problem is currently record low IPOs, a significant reduction in venture funding. They are seeing their own share prices fall. They're not able to generate liquidity for the company. I've left for last the area probably with the greatest distress and the area probably that you all can currently get the most work in. And that is the real estate sector. In particular, in the commercial real estate sector, the current economic uncertainty have created several real estate losers, but also several real estate winners. And you've all seen or read about the significant commercial real estate issues in the largest market. San Francisco particularly has severe commercial real estate issues. New York also, Chicago, where I'm located. It's personally distressing to see so many vacant storefronts in my adopted city. But there's many who say that once the creditors and lenders take the hit, developers will be able to lease out property at lower rates, and that may cause a resurgence. For example, if many of you know LaSalle Street here in Chicago, from roughly where the State of Illinois building is, for those who know that building, LaSalle Street and Lake Avenue, all the way through to the Board of Trade and the Federal Reserve, that whole LaSalle Street corridor is significantly declined. Largest businesses, big law, big CPA firms, big consulting firms have relocated to the West Loop or Wacker Drive. And so the solution to that has been the former mayor started a program where that area is now going to be all redeveloped as housing versus commercial real estate. So these headwinds may ultimately provide an opportunity for innovative ways to restructure and repurpose underperforming assets, and there may be a role for business valuators there. I just returned from Brooklyn and I saw several office buildings in the process of being repurposed as residential, and maybe that is part of the solution. That ends my presentation. I don't know if there's any questions, but I think it also ends my time slot.
Thank you, Mr. Pakter. There is no questions, or unless there is someone that wants to one now? There's none. So thank you for your time. And
You're very welcome. Thank you for having me on.
Thank you. So now we have our next polling question. So make sure you respond to that. And our next session, we'll have Jeannie, one of our correspondents. She's going to be interviewing our panel judges, and we are going to have Michael Kaplan with her too. Take it from here, Jeannie.
Great, thank you. All right, I hope you all were able to join in at the conference to hear Michael and Judges Yates, Platt, and Driscoll. It was a great session. I'm excited to have Michael and Judge Platt with us today to discuss what to do when errors are found in your work or the work of someone else in your office at trial, or perhaps after you've been deposed. And Michael Kaplan here is going to give us more of an expert's perspective on this, which I'm really excited to hear. So I will open up Michael and Judge Platt with our first question and kind of setting up the scene that we all hope and strive to avoid errors going out in our work. And if we do issue a report that has some errors, we would hope to have caught them before trial to be able to issue some sort of correction. But in the very unfortunate event that there is an error or a misunderstanding of facts or circumstances that's discovered at trial, for example, what are some things that the experts can do on the stand to make the situation better, or at least not worse?
I can start, and I would start by saying, first, before we decide what to do, why don't we decide what not to do?
Sounds great.
What not to do, in my mind and my experience, is, notwithstanding the fact that you are, quote, surprised, act like you're not. You are an expert. You've been presented as an expert. You're being presented as someone who, at least in your area of expertise, is smarter, in quotes, than everyone else in the courtroom. Experts can make mistakes, and that can happen. And if properly presented as a mistake that the expert made, the difference between an expert and a non-expert in the minds probably of most of the lay people in the room is experts can make mistakes, but they're never surprised because they're experts and they're smart. And that means that they're not only make mistakes, but they are and not surprised by them. And because they're not surprised by them, they know how to correct them. So you identify it, you're not surprised, it's a matter of routine, and you then correct them as a matter of routine. And nobody thinks that you were surprised, because smart people are never surprised. And you're not in this particular instance. Also, be prepared to answer the inevitable question once the mistake is identified and corrected. I'm trying to think if there was ever a time where this question didn't get asked, by at least on direct and probable. Is there any, as a result of finding this mistake, and you've now acknowledged it, Madam or Mr. Expert, does that change your opinion in any way? If it does, how does it change it? And of course, the answer to that is hopefully doing the least amount of damage possible to the opinion and to the expert and to the case that you were hired to facilitate. And if it does not change it, why not? And that would and if you're not on the stand when this happens, then of course communicate with counsel that he or she doesn't panic, because they just got surprised, even if you didn't, or at least you're able to give the appearance that you didn't. And they should, hopefully you can confer, and don't ask for a break if you're on the stand, because that looks like you don't know what to do, and you need to talk to somebody. And the world that we live in, which is naturally made up of conspiracy theories to begin with, particularly as directed at experts, if you ask for a break and you're talking and that means you want to talk to somebody, that means your testimony was rigged. to use the words that one of our favorite people uses all the time. But counsel needs to know what to do and what questions to ask to allow the mistake to be identified, corrected, minimized, and still have your opinion have the effect that it was intended to have, which is to facilitate a victory in their case. Michael's mute.
Yeah. We see the mouth moving. We're excited.
Now I'm not mute.
Okay.
I'd like to address that from the expert's perspective, because Judge Platt is absolutely right. And as an expert, and I've done a lot of trials in my time, about approximately 300 trials. And just when I think I've seen it all, something new arises. So about 15 years ago, I was on the witness stand in a case. It was an employment case. It was a wrongful termination. I was brought in to measure and opine to the amount of lost earnings and benefits that the plaintiff had suffered as a result of being improperly terminated. And this was a case where we had all of the documentation that we needed to put it together. I had my absolute best staff person working on it. I mean, someone who just did beautiful work, whose work was accurate, who knew what she was doing and putting it together. She worked under my direction. I explained what I needed and the evidence that we had and how to incorporate the evidence in, but she put it together for me. I got to my deposition. I gave my deposition. Everything went well. Back in those days, it was not uncommon in a wrongful termination case to assume an age 65 retirement date. And that's what we assumed, that this lady would retire at age 65. After my deposition, I got a phone call from my retaining counsel, and he said, Michael, I know one of the areas that opposing counsel is going to come at us with, he's going to come back at us and come back at you when you're on the stand, relating to the date of retirement, because their position is she would have retired at age 55 or age 60. She would not have stayed there until age 65. He said, please do alternate calculations in order that we can respond to them, in order that you can respond to them appropriately when you're on the witness stand. So I went back to my staff person and I told her, I said, we need to run 2 alternate calculations, same model, same input, but except we make the adjustments to bring it to age 60 for one iteration, age 55 for the other iteration. She got it all done. Her work was, she put it together, put the file together. Her work was reviewed. It was re-reviewed, ticked and tied, and all the mathematical calculations. And then I reviewed it. I reviewed it prior to my testimony. I was on the witness stand in the courtroom. When we got to trial, I was on the stand. And this was a trial where things were going so right. During my direct testimony, the judge interrupted me twice to tell me what a good job I was doing of explaining this to the jury. Well, while all of this was happening, I'm realizing, when is the other shoe going to drop? So I finished my direct testimony, and opposing counsel, his first question out of the box was, Mr. Kaplan, you want your work to be as accurate as possible, don't you? Well, when I hear that question, that means there's a footing error somewhere. So I said, that's what I strive for. I strive for my work to be as accurate as possible. And his next line of questions revolved around a document that he put in front of me. Mr. Kaplan, do you recognize this document? I said, yes, I do. And this document presents the retirement factors for the public employees retirement system, doesn't it? I said, yes, it does. And you use this document in your analysis? Yes. And you use numbers from this document in your original analysis and your updated analysis? I said, yes, I did. And he said, and isn't it true, Mr. Kaplan, that you used the absolute wrong retirement factor in your calculations relating to age 55 and age 60? And I looked at the document, and I had my trial file with me. I flipped it open. I looked at the number that I used. I looked at the number that was on the schedule, on the chart. And I realized that every number had been updated in the new analysis except for the retirement factor. Somehow my associate included, she just continued on with the old retirement factor. No one caught it. I mean, the two reviews and my review, no one caught it. And I realized that we had a problem here. And at that point, I said to myself, Michael, now is the time for 40 years or 35 years of experience to kick in. Pull this one out of the water. And I looked up at opposing counsel and I said, I need to check something here. And what I did is I took out my phone. Went to the calculator, and I recalculated. I did all of the age 55 calculations again by hand, with the assistance of my calculator. All of the age 60 calculators, all of the age 60 calculations again. And while I was doing this, opposing counsel was trying to move on to something else. Your Honor, let's go on to something else. And she said, no, Mr. Kaplan he said he needed to check something. So let's let him check it. And I looked up at him when I had all the calculations done. I looked up, I said, counsel, you are absolutely right that there was a more appropriate retirement factor that should have been used at age 50 and a more appropriate retirement factor that should have been used at age 60 or at age 55 and age 60, and incorporating in the correct retirement factors. The age 55 number is, and I gave him the number, and the age 60 number is this. And then at that point, I turned to the jury and I said, ladies and gentlemen of the jury, please forgive me for being human. And then, anyway, he completed his cross-examination. Under redirect, my retaining counsel, first question is, Mr. Kaplan, you made a mistake, didn't you? Yes. And it was a fixable mistake, wasn't it? Yes, it was. And you fixed it. I said, yes. And after you fixed it, these are the numbers. And he walked me through the numbers. And I said, that's correct. And I just brought the thing around. The thing is, when you're on the witness stand and you get caught in an error, you own it. I realized I owned that, even though it was my associate who actually brought the wrong number in there. But when I assign something to someone, I'm on it. And it's something we strive for perfection. We strive to get it right. Well, there was an error. That happens. And it worked out well. At the break, my retaining counsel pulled me aside and he said, Michael, when I heard that question about the wrong retirement factor, I thought your testimony was just going to unravel. He said, I have never in my life seen an expert recover as quickly as you did. I said, I own it. I had to do what I had to do, and I had to be honest. And being honest, I'll tell you, that's something that I know the jurors look for. They want you to tell the truth. They want you to be humble. They're looking for honesty.
I just reinforce that that jumps ahead to your last question. But I think it's important to get focused in case we run out of time. That Michael's point, I think, reinforces mine and mine reinforces his. But beyond that, owning it, the worst thing you can do, and I've seen it happen, is blame anyone, including your own staff, for a mistake, even though that person may have been the one that made the mistake. You own it, and you don't mention anyone else's name, because jurors don't like that. And judges don't like it either, and part of your ability to project as an expert is not only that you're smarter than anyone else in your area, but you're likable. And likable equals credibility. And if the jury doesn't like you, whether you're the brightest person on the face of the earth in your subject matter, it isn't going to matter. They're not going to want to pay any attention to somebody they don't like.
Very interesting. Now, with that story, Michael and Judge Platt, Judge Platt, do you feel like that's pretty common for a judge to allow the expert time? If you say, hold on, I need to check something. Is that more common, or more often than not that a judge would allow an expert to go?
Put it this way, a good judge will allow the time and a bad judge won't, and there are both.
Okay, fair.
But the bad judge, literally, who doesn't allow them what appears to be a reasonable request and time, may get to read about him or herself by an appellate court, because that's known as an abuse of discretion.
Okay.
So bottom line, ask for what you need, respectfully, politely, but ask, and depend on the fact that the judge is human and hasn't forgotten how he or she got where they are.
Okay, so I'm taking away from both of your comments combined is, don't go out for a break where it's kind of seen as behind closed doors and where assumptions can be made about what's happening. If you need some time to correct or rehab your work, do it there on the stand, out in the open in front of everybody.
Yeah, the reason not asked to break is not so much that there's anything wrong with that. I mean, in effect, what Michael did is ask for a break, but he said, in order to for me to check my records. So the judge knew, and everybody in the courtroom knew, why he was asking for additional time, as opposed to, I need a break, in a panicky tone, because unfortunately in the world we live in, people draw a negative conclusion more than they do a positive conclusion. And the negative conclusion in the world that we live in is this is all rigged, and he's looking for whoever it is that did this for him, and he's in cahoots with the bad guys of the world, and so forth. It sounds like I'm exaggerating, but unfortunately that is what's going on. And experts, the word expert is being attacked politically as well as across in courtrooms, and some of what sells in politics sells in a courtroom, or at least some lawyers think it does, and they will attempt to draw that negative inference from behavior that, if looked at objectively, isn't negative at all.
Very good. So does an error necessarily mean that the rest of your work will be given little credibility?
My answer, the short answer to that, is not if you do what we just said.
I would say that life is not so much a function of the things that happen to you, but a function of how you respond and react to the
Right.
things that happen to you. So notwithstanding the fact that an error is problematic, and an error that is discovered on the witness stand is problematic, but once it's there, once it's a given, the jury is going to be looking at how you are responding. And if you respond honestly, and it becomes clear that your intention is to give the correct testimony based upon correct numbers and professionally completed work, the jury will recognize that. And just because you got that one thing wrong, if you fix it, or I should say, especially when you fix it, I don't think that will negate anything that you testify to afterwards. You know, your opinions generally stand on their own, unless the jury perceives that you're trying to hide something, you're being squirrely. I've seen that.
Very good.
I represented an expert, a doctor, who wrote a book on how doctors should testify in the courtroom. And he was always asked the question on cross after, and the word on him was that he went both ways, meaning he'd have opinion. But anyway, he was always asked, doctor, when you were asked on direct examination, whatever the question was, you answered in the following way. Is that because that was the answer under oath, or was that because on page 56 of your book, you said, if you ever get asked that question, answer it this way? He had a great response. His answer to that question was both.
Very good, man. I love the creativity. If I could be a fly on the wall on some of these trials. So how should an expert expect their retaining attorney to react to errors found at trial?
You want the reaction of a good attorney or a bad attorney? Then both. But the bad attorney will look for, particularly if the result is not what he or she wanted, will look to blame somebody, and it'll be you. The bad attorney, the good attorney, will admire what Michael did in his case and what a good, experienced, competent, smart expert will do in his or her case, and be grateful that recognize a human being makes mistakes, even if they're experts, that you knew how to correct it, you're professional, and will be very happy that the things went the way they did. And that's whether the result is what they would hoped it to be or not. But where they're human beings and they react in the way that they normally react. But as Michael said, the test is how'd you handle it? Not so much that you made a mistake.
Michael, do you have any thoughts?
I agree wholeheartedly with everything that Judge Platt said.
Would you expect, say in that case with the attorney's comment that he had never seen an expert recover so quickly, that would actually have been an additional reason for him to call you back and retain you again?
I like to think so.
Have either of you seen instances where you think it's pretty clear that the attorney wouldn't hire the expert, and what are some of the keys to that? The differences, the contrast between what Michael did and what other experts who've made mistakes.
My personal opinion is that, again, as Michael said, and I couldn't agree more, it's not so much that you got hired, you're going to get hired back because you didn't make a single mistake, as opposed to if you did make a mistake, how you corrected it, how you reacted to it, which is true in life, but and also in a courtroom. But you'll be hired back if chances are, if the result was not what had been expected, there's a combination of reasons why an expert might, if the attorney is trying to blame someone other than him or herself, you're a good target. And if they don't, that's a reason for, as a business, and you are in business, if you have that kind of attorney, you need to know who hired you, and know how they operate. Your fee is at risk if it hasn't been paid. And that's a good reason to make sure that it's paid in a way that that can't happen. And as far as hiring back is concerned, they get it. If you think they do a good job, you're going to if you handled it well and the result was okay, or at least satisfactory, lawyers are like everybody else. You start saying you don't like the performance of a particular expert, or for that matter, a particular lawyer. Well, then the next question is, you have some alternative in mind that could do better. And that's true of not only experts, it's true of lawyers, it's true of mediators, arbitrators, not true of judges because you don't have any choice, but but they're, that's why the term judge shopping got invented. So, but a lot of lawyers, know what they want. They just haven't dawned on them yet that they can't get what they want all the time. So they have to take the best that's available, and the best that's available are, whether it's an expert or anyone else, it's not somebody who never makes mistakes.
I appreciate both of your comments. You succinctly covered, not throwing anyone under the bus in your testimony, whether or not that someone, truly made a mistake and you relied upon it, that you own that. I appreciate that. And I appreciate you guys discussing the damage control and ways to best handle the unlikely, hopefully, and unfortunate event of an error being caught maybe on the stand or shortly before trial. And I'll turn it back to Alina. Thank you so much.
Thank you, Janae, and thank you to Judge Platt and to Michael Kaplan. We have one of our polling questions, but now we are passing to Roberto Castro. He's one of our correspondents, and he's going to be interviewing. Give me a second. He's going to be interviewing Karen Caseno and Jeff Urbach, and they are going to be talking about helping clients deal with the backlog in the family courts in 2023. Hola, Roberto.
Hola. Hi, Alina. Can you hear me?
Yes, sir.
Okay.
Yes.
All right. Wonderful. So can you see my screen at this point? Let's see. Okay, perfect. So, we've got two extremely experienced professionals in the field, Karen Caseno and Jeffrey Urbach, seasoned, really smart individuals. And this is a brief presentation. There will be a subsequent presentation that they're going to be offering for over an hour. And there's going to be a sign up for people that are interested in basically taking that additional course a little bit later. So with that said, Karen, can you hear me?
Yes, I can hear you.
Jeffrey, can you hear me?
Yes, long time no see. Good to see you again, my friend.
Great to hear from both of you. Brings back great memories.
Yes, it does.
It's so let's get to the point. We've got a few minutes here, and we're going to here we go. I had more hair there. Now here we go. So there you go. Very well established individuals, smart, and let's get to the topic here. So helping clients deal with the backlog in the family courts in 2023. And as you can see, there's going to be an hour webinar that's going to be offered a little bit later today. Sign up, get some information from NACPA. So
yeah,
so let's talk about it. What's happening in family courts for what do you guys think?
Yeah, so it's kind of like real estate. Everything is local. Okay, so I'm going to be talking from an East Coast perspective, and particularly in New Jersey, and even within New Jersey, we have 21 counties. We're the most densely populated state in the union, and we have got a lot of problems. And my practice has been like Karen's, decades old, and almost exclusively in the area of family law, evaluations, forensics. And many years ago, I got myself qualified as a mediator. New Jersey has a formal judicial roster that one can qualify for. And so, and I'm also involved in the collaborative law movement, was one of the initiators of that in the state of New Jersey. So I bring a settlement-oriented mindset to the work that I do. That being said, we have an acute problem in New Jersey. We have 21 counties. We have 6 counties where we have 3 counties where they have already told litigants you're not getting a trial, period, full stop. Okay. Unless it's an emergent situation, domestic violence, that kind of thing. We have another 3 counties that are now saying, well, we can give you a trial, but it's probably not going to be for 3 years. Okay, we have an acute shortage of judges in New Jersey, which is a political issue that I'm not even going to get into, and frankly, I don't even fully understand. That being said, having been doing this work a long time and knowing a lot of the lawyers and many of the judges, although at this point in my life, most of the judges are half my age, but that's okay. Many of the judges know that, first of all, I only do neutral work. And I don't do what, I don't like the expression, but they call it partisan work. I don't do partisan expert work. So what's been happening is I will come into a case as a neutral, and it's typically a small business valuation, determination of economic income, going through the forensics, the perks, and all of that. And because of the inability to get a trial, okay, many judges are now, at least the ones that I know and that know me, are saying, Jeff, you're on the roster as a mediator. Do you think you can help the parties mediate a settlement? And I'm flattered when I'm asked to do it, and I'm always more than happy to give it my best effort. Although I tell everyone that mediators don't settle cases, clients settle cases. All we can do is try to help clients get to a self-determination solution. So that being said, there's a technicality that we have to be careful of, and then I'll shut up and turn it over to Karen. When you're, and I can only speak again for New Jersey, so we have rules of court which deal with our various responsibilities, both as experts and as mediators. So what happens is, if a judge says to me, Jeff, we'd like you to try to mediate the case, what I do is I have to have a conflict waiver signed by the attorneys and signed by the clients. And if you take the webinar that we're offering later on this afternoon, there's a sample of the document that I use, again, which is for New Jersey. So your mileage may vary. And basically, essentially what it says is, look, you've hired me as a neutral. Now you want me to mediate. If the case doesn't settle under the standard rules of mediation in New Jersey, my further testimony cannot be called for because of rules of confidentiality. But you're waiving that. You're going to say, okay, if you mediate and we can't get to a settlement, you're going to issue a report and we're going to allow you to talk about whatever it is you need to talk about. And so I think it's very important that one covers themselves professionally, or you can find yourself in a situation where you're in a violation of all sorts of ethics rules. And not only that, the clients might find themselves in a situation where, oh my God, now Urbach can't testify. Now I got to go out and spend another $10,000 to have the work redone. So with that, I'm going to shut up and let my good friend Karen Caseno tell us what's going on in California.
Thank you.
Go,
Jeff
Karen.
and I have been working together teaching for, I think it's been 25 years the first time.
At least.
We don't want to.
And we're getting younger by the day, Karen.
So I agree with everything Jeff said. I know we have a short period of time, so I want to just, I pretty much agree with everything he said. I'm in San Diego County in California, and we're not as bad. We're not 3 years out. We're more a year to 18 months out. And once in a while, people can get emergency hearings, maybe 6-9 months out. But a few pointers. The first thing is, and I do work for one side. I do a lot of neutral cases. Jeff just says neutral. So a couple of pointers for all of you out there, at least in our area, because of this backlog, because the judges want things to go away. They want their docket to get clear. They want cases to resolve. We need to take the bull by the horn, even when you're just working for one side, and try to figure out, okay, there's 50 financial issues. Which ones can we get resolved? Which ones can we get some kind of common sense answers to, so that we get down to the 3 or 4 that we really need to fight about? So take in collaborative, which Jeff and I do a lot of, the financial neutral kind of runs a lot of the meetings and runs a lot of the process, especially in the property division. So if you have the personality type or the experience level that Jeff and I have, take over in terms of, talking to your attorney and say, let's talk to the other attorney. Let's get let's figure out what we have agreement on and which issues are the sticking points so that we can concentrate our time and effort on those issues. And, really try to get to the point where there used to be 50, now there's 3. Now, here's where we need to go to a settlement conference judge on those 3 issues. Or if we have to go to trial, there's 3 issues, there's not 50. And we really can be a good tool in the system there and really kind of force that issue and keep bringing it up and present analysis that maybe take their schedule of assets and debts or whatever it's called in your area and say, all right, it looks like, we're within the range on these issues. Let's talk about these issues here. One of the things that the judges used to require here in San Diego that we don't require anymore, but a lot of the judges will do is they'll tell us when we've got experts that are fighting over these big issues, that they'll say, prepare a memo of your agreements and disagreements. Why? Because the judge doesn't want to hear your testimony and hear the other side's testimony and be in the position of having to understand these complex financial issues and then having the judge decide, I need to make a decision on what's right. Really what they want is for you to say, here's the issues, here's what I think, here's what the other side thinks. It really comes down to 3 things. We're disagreeing on the cap rate, we're disagreeing on the representative net income, and we're disagreeing on how to treat the PPP money. So we have the issues identified, then we can, talk about what the other side's doing, what we're doing. So as much as we can be helpful as possible. Then the other big thing too is don't go to trial. So we finally get to trial. What the judges hate more than anything, with as much backlog as there is the old-fashioned, I'm just presenting my analysis, the other side's presenting their analysis, and we're poking holes at each other and we're calling each other names. I never practiced that way, and I'm guessing, Jeff, you probably didn't either, because we were trying to come up with answers. So even if the case doesn't resolve and we do this where we're trying to resolve it and mediate ahead of time, it still goes to trial. Try to talk to your attorneys about, let's present the financial matters in an easy to understand way that focuses on the important points. Yes, the other side is wrong about these 18 things, but what's going to give information to the trier of fact so the trier of fact can make a conclusion, and we're making it easier on them, especially if you've been around as long as Jeff and I have. They look at us and they go, come on, Karen, come on, Jeff, I need answers from you. I don't want a bunch of, well, she flagrantly decided to, I don't do that.
I want to add, I just want to add something to everything Karen said is spot on. And I think I think what's important, if you're going to go into it, if you're going to specialize in family law, there's a mindset that you're either going to have or you're not going to have. If you're going to be one of these, I know how many angels will fit on the head of a pin type of expert, you're not helping the judge. You're not helping 2 people who are at the worst point in their lives try to get over a very difficult situation. And so my philosophical approach to all of this is, you know what? You want to disagree with my cap rate, you want to disagree with my reasonable comp, whatever it is. At the end of the day, we've got to get these 2 people divorced. They need to get on with their lives, and they can't spend the entire marital estate on experts like Karen and I and other experts, child custody, God knows what else is involved. So I almost look at it like I'm providing a public service. And I think at least that's how I've been successful in my own career, by having that mindset. Quite honestly, there are many attorneys that will not hire me, and that's okay, because I don't want to work with them either. Okay.
Which brings up another thing that Jeff brought up is, don't be afraid to say no. I had a trial recently, and the other expert, the attorney said, I want you to talk about the numbers only if this is valid. But it wasn't. We knew there was questions about the validity of whatever document this was. So I said, we should present to the court a couple of different ways, just so the court has some data. Well, the attorney won't let me do that. And I would insist upon it. And I would say, that's not going to be helpful. And I kept saying to the other expert, what your testimony is going to be not helpful at all. can we at least do a document where it says, if, you don't disagree with what I did and my calculations were right, you're just assuming something else. Can we do that? Because then that would be helpful to the court. No, I can't do that. The attorney won't let me. And I wouldn't do that. I would say, I'm not doing that. I need to be credible and I need to be helpful to the court. And sure enough, we went to trial and the other side testified for a day and a half about all this stuff that was not helpful. And at the end of this expert's testimony, the judge asked a couple of questions and said, you know what, I found your testimony not helpful at all. And I thought, well, you know what, they don't always say it to confirm it, but it was not helpful at all. So, so that's, we're down to our last minute, I guess, on, be a tool, be helpful. Don't let them tell you what to say or do. You know what you're doing, and make sure you don't lose your credibility, and that you try to be helpful and as objective, even when you're working for one side, as you possibly can.
Karen, if it's possible in 30 seconds, how can a NACPA member, whether who's a CVA, how do they get involved in being a mediator? Can you just give us a little plug? What is it that you need to do in order to be a neutral or be considered a neutral and available for cases like yours?
So being a neutral, the courts, depending upon what area you're in, will appoint you as a neutral on a lot of cases. As Jeff said earlier, he gets appointed, as do I, as a neutral. So you're working on the calculations for both sides. But mediating and actually working with both parties as a mediator, that's kind of a step beyond.
Gotcha.
And so
Right. And every state has their own mediation rules. For example, in New Jersey, we don't have quote unquote certified mediators. We have people that are on the judicial roster that have met certain educational experience requirements. People are in New Jersey are allowed to go to private mediation, where you can pick a mediator with no specific pre-expertise expected, etc. Everything again is local. So find out what's going on in your county and in your state and what your rules are. In New Jersey, we have a New Jersey Association of Professional Mediators. I'm on the faculty. I've been teaching for them for almost 20 years now. And frankly, that's how I get a lot of my business. So.
Okay. Well, listen, both of you, thank you so much.
Thank
And
you.
we look forward to your 1 hour presentation a little bit later this afternoon.
Great.
Thank you.
Wonderful.
Thank you, Karen, Jeffrey, and Roberto. And we have our next polling question. And as Roberto mentioned, if you participated on this ABW show and you're interested in watching the 4 p.m. Eastern Time presentation that they are going to be doing, you will get a 20% off. So make sure you write down the promo code that is on your presentation so you can, take that discount. And now we're going to have Will Casserly. He is from Hinge, and he's going to be talking about how to grow and build your brand. Go ahead, Will.
Thanks, Lane. I appreciate it. I'm going to go ahead and share my screen. Let me know if this comes up for everyone.
Yes. Came up.
Excellent. So yeah, I am Will Casserly with Hinge, and I really appreciate the time today and appreciate our long-running partnership with NACPA. For those who are just being introduced to Hinge, we are a branding and marketing firm, and we exclusively work with professional services firms. So accounting firms, architecture, consulting, government, legal, tech firms, and such. And through our research arm, the Hinge Research Institute, we do a good deal of qualitative and quantitative branding research on behalf of our clients. And we do a lot of that with industry research to really understand trends and what's happening out there. And we share a lot of that information on our website and our materials. So do feel free to check that out. One of the things that's coming up, I did want to mention also, is our annual high growth study, where we look at what the highest growing, fastest growing, most profitable firms are doing differently within each industry. The 2024 edition is starting. The research for that is starting. So if you are on our mailing list, you'll get an invitation to join that study as well, and encourage you to do so. So today, we wanted to take a look at some insights for one of our studies for the accounting industry. So the accounting marketing budget benchmark study. We've conducted this study for over a decade now in partnership with the Association for Accounting Marketing, and it's now in its 6th edition. This year, a little over 100 firms participated, representing revenues in excess of $6 billion and more than 950 offices. You can download the executive summary for free from the AIM website, or the full research study is also available for purchase as well. And today we're just going to be looking at a couple highlights from this study that are of interest. The full study features a wide range of accounting firm benchmarks, things like firm profiles, the types of services offered, the ratio of marketing staff to full-time employees, what different marketing techniques those firms are using, and drills down into some of the things about the importance of culture within firms, and also technology and digital maturity ratings. And all of this is with an eye towards what are the fastest growing firms really focusing on. By looking at this marketing spending, we get a very clear image of where firms are allocating their marketing dollars and how the high growth firms differ from their slower growing peers. And also looking forward, where are firms looking to increase or decrease their spending going forward into next year? And before we dig into some of these highlights, one of the interesting call outs was the role of valuation services within accounting firms, which I thought we might want to take a look at today. We asked the question, what services do your firms offer? And not surprisingly, of the top responses, and this list is just the top 6 responses of a much larger list. While there wasn't a primary focus of this particular study, it's notable that just after the core services, when we're looking at tax and audit and advisory and consulting services, valuation was one of the largest offerings inside of there. We also segmented this out. So looking at the size of the firm. So small firms, mid-sized firms, large firms, and major firms. 100% of the major firms offered valuation services within their offerings. 70% of large firms, about half of the mid-sized firms, and just under a quarter of what we call small firms, just under 4 million. So when we look at the study itself, the entire study is broken down into 5 major categories. So we took a look at everything. We broke it down into digital content marketing, so more current digital marketing techniques, also broken down into conferences and events, what firms are doing with traditional marketing techniques, also what's going on with their advertising dollars, and also people and resources. In this chart, we see on the left-hand side how high growth firms represented on the left and low growth firms represented on the right. So the biggest call out inside of this is looking at the people and resources section here, that blue bar at the left at 64.6%. It's really indicating a greater investment in talent. In fact, moving forward, 100% of the high growth firms plan to increase spending on talent. And this is really reflective of what's being faced inside of that industry with the ongoing challenge of recruiting people and retaining talent inside the industry. Another measure in this study we look at is the ratio of marketing staff to full-time employees. How many staff are really needed to effectively support a firm? The average for high growth firms, the ones performing better, is 1 marketing staff for every 42 full-time employees. In comparison, the ratio is 1 to 65 for the firms that are only growing at an average rate. We also look at, when we look at this increase for the high growth firms inside of people and resources, what's the opposite side of that? Where are they pulling back? And we see where that reduction really is inside of traditional marketing techniques. So when we think about things like printed marketing materials, brochures, business cards, also extending into direct mail, award submissions, more the traditional marketing techniques, there's a little bit of a pullback in that area. So digital and content marketing has been playing an increasing role over the last few years, even elevated more so through the pandemic. We see website and maintenance continue to lead in this category. It's not really a surprise since websites are the hub of any firm's visibility. Low growth firms are actually allocating a higher percentage than the high growth firms in this area. And we believe that's more of an effort to really catch up to where some of the firms have already made those investments. But what's interesting inside of that, it's fairly easy to understand that the website is an important component, but that's not the number one investment either firm's making at the moment. What is search engine optimization, or SEO. Not only now, but even moving ahead, it is the top increasing segment for high growth firms. And the takeaway from that is that it's not enough to really just build a pretty website if it isn't going to perform for you. So when we think about SEO, we want to remember that that's not a one-time event. We don't build a website and then just run through an SEO piece to adjust things. It's really an ongoing strategy. It's part of our regular implementation, and it's built into the ongoing strategy. So SEO shouldn't happen once and then go away. It's something that happens on a regular basis, monthly, and should be closely tied to your analytics. And we're regularly having conversations with firms who've gone through some sort of website redesign in the past year and a half or so. And what they're finding sometimes is that they're not seeing any increase in lead flow, or perhaps in some cases even a decrease in lead flow. Even though the site may look better, maybe fancier, it's not performing in the same way. And they're left questioning, where have things come off the rails? And these are things that we usually advise taking people through a website audit to really help uncover exactly what's happening. Another thing we looked at in this study was advertising spending. In the advertising category, there's a clear shift to digital formats. Digital advertising was the budget leader for high growth firms at a little over 43%. Social media advertising was trailing very far behind it, only about a little over 5%. But what this chart represents is looking ahead into the next year. So where are people increasing budget spending? And look who's getting that big bump next year. It's social media advertising. In fact, 28% of high growth firms are more likely to include social media advertising in their marketing budget. And what we see inside of here is a lot of firms have gone through a lot of testing. Our recommendation is that with advertising testing, it's really a test and repeat. You need to figure out, each firm needs to figure out what their formula is that works best for them so far as digital advertising. And once you isolate it, do a lot of A/B testing, figure out what works, then really invest more in that ad spend itself. But what we're seeing here is that not only are firms, the ones that are a little bit further along, have they figured out some of these digital advertising techniques and started to master them, they're starting to move into extending that into the social media atmosphere. So what advertising can they do on social media, especially when it comes to talent acquisition and really finding more qualified people? So as I mentioned, you can download the executive summary for free from the AIMS website. The full report's also offered for purchase as well. For members, it's considerably, there's a discount involved in that for AIM members, or is available to anyone as well. Also wanted to mention that if you're interested in more about marketing for yourself or marketing when it comes to valuing other firms, encourage you to connect with me on LinkedIn. Always happy to have a conversation. There's also a special offer for NACFA members. Hinge University marketing classes start with this coupon code for only $10 for the first month, and have a wide variety of information available online. There's also, if you're interested in learning more about the accounting marketing budget itself, I encourage you to read the blog, The State of the Modern Accounting Marketing Budgets, or watch our webinar, Building a Better Accounting Marketing Budget online too. Both of those are available for free. And appreciate your time today.
Thank you, Will. Thank you for that important information. For the rest of you, we have our last polling question, so make sure you respond to that. And thank you for joining us. You are invited to attend next month broadcast on August 21st. So make sure you put it in your calendar. And thank you for joining all our presenters and our collaborators and correspondent.